Good day. We will begin with a brief summary of the case law that governs arrest, search, and seizure. But let us be honest with one another. A summary is only the doorway, not the room itself. Knowledge rewards those who linger within it. The details are where understanding takes shape. These cases explain when an officer may act, when restraint is required, and why the Constitution permits both. They do more than list permissions. They reveal judgment, balance, and discipline in motion. So stay with this material, not just to recognize the names, but to understand the reasoning behind them. Because God is in the details, and excellence in this profession is built there, quietly, deliberately, and with respect for the limits of authority. With that in mind, let us begin. Court cases referenced in arrest, search, and seizure. 1. Brinegar v. United States, 1949. Established that probable cause is based on practical, reasonable judgments, not technical certainty, and allows officers to rely on training and experience when making arrests and searches. 2. Carroll v. United States, 1925. Created the automobile exception, allowing warrantless searches of vehicles when officers have probable cause due to the vehicle's inherent mobility. 3. Beck v. Ohio, 1964. Held that probable cause must exist at the time of arrest and cannot be justified later by evidence discovered after the arrest. 4. United States v. Sokolow, 1989. Confirmed that reasonable suspicion is based on the totality of the circumstances, even if individual factors appear innocent when viewed separately. 5. Florida v. Royer, 1983. Clarified that a consensual encounter becomes a detention when officers restrain a person's freedom of movement without reasonable suspicion. 6. Terry v. Ohio, 1968. Authorized temporary detention and a limited frisk for weapons when an officer has reasonable suspicion that criminal activity is afoot and the person may be armed and dangerous. 7. United States v. Mendenhall, 1980. Defined a seizure as occurring only when a reasonable person would not feel free to leave, establishing the standard for consensual encounters. 8. Dyer v. State, Texas Criminal Appeals Court, 2003. Held that observations made during a lawful traffic stop may establish probable cause to arrest and justify a search incident to arrest. 9. Payton v. New York, 1980. Ruled that officers may not make a warrantless, non-consensual entry into a suspect's home to make a routine felony arrest absent exigent circumstances. 10. Illinois v. Gates, 1983. Replaced rigid probable cause tests with the totality of the circumstances, standard for evaluating search warrant affidavits. 11. Miranda v. Arizona, 1966. Required that custodial interrogation be preceded by warnings advising suspects of their rights to remain silent and to an attorney. 12. Maryland v. Schatzer, 2010. Held that a break in custody of 14 days or more ends Edwards' protections, allowing officers to reinitiate questioning after Miranda rights are reissued. 13. Krieger v. State, Texas Criminal Appeals Court, 1997. Clarified the concept of curtilage and reinforced that areas intimately associated with the home receive Fourth Amendment protection. 14. Stegould v. United States, 1981. Held that an arrest warrant alone does not authorize entry into a third party's residence without a search warrant or exigent circumstances. 15. Brigham City, Utah v. Stewart, 2006. Recognized the emergency aid doctrine, allowing warrantless entry when officers reasonably believe someone inside needs immediate assistance. 16. Kentucky v. King, 2011. Held that exigent circumstances justify warrantless entry as long as police did not create the exigency through actual or threatened Fourth Amendment violations. 17. United States versus Santana, 1976. Applied the hot pursuit doctrine, allowing officers to follow a suspect from a public place into a residence to complete a lawful arrest. You've seen the doorway. Now let's step into the room itself. The summary gives you the names. What follows explains why they matter. These cases were not decided in the abstract. They were shaped by real encounters, real decisions, and real consequences. Stay with the details. They will serve you long after the names fade. Brinegar v. United States, 1949. Brinegar v. United States is where the court defines probable cause as a practical standard grounded in reality, not perfection. In Brinegar v. United States, the court makes clear that probable cause does not require certainty, nor does it require proof beyond a reasonable doubt. Probable cause exists when the facts and circumstances within an officer's knowledge would lead a reasonable person to believe that a crime has been, is being, or will be committed. Under Brinegar v. United States, law enforcement officers are permitted to rely on observable facts, reasonable inferences, and their training and experience to establish probable cause. The court recognizes that officers must often decide quickly, with incomplete information, and that the Constitution allows action at the level of probable cause, not absolute proof. At the same time, Brinegar v. United States imposes discipline. Probable cause may not be based on a mere hunch, generalized suspicion, or hindsight justification. The officer must be able to articulate specific facts that supported the decision at the moment it was made. The law allows reasonable judgment. It does not tolerate guesswork, what Brinegar v. United States was. Brinegar v. United States arose from a vehicle stop and search conducted by federal agents who had prior knowledge of Brinegar's involvement in illegal liquor transportation. Based on that prior knowledge and their observations during the stop, the agents searched the vehicle and found contraband. The issue before the court in Brinegar v. United States was whether those facts were sufficient to establish probable cause under the Fourth Amendment. The court held that they were. In doing so, Brinegar v. United States confirmed that probable cause is evaluated based on the totality of the circumstances known to the officer at the time of the decision, what Brinegar v. United States requires of law enforcement. Brinegar v. United States requires officers to ground their actions in articulable facts. An officer must observe behavior. An officer must interpret circumstances. An officer may rely on training and experience, but only to explain facts, not replace them. Under Brinegar v. United States, probable cause exists in the space between suspicion and certainty. Officers are not required to wait for proof sufficient to convict, but they are required to act with reasoned judgment, supported by facts. Mistakes may occur. Unreasoned actions may not. Summary: what Brinegar v. United States did for law enforcement. Brinegar v. United States establishes probable cause as a practical, workable standard for law enforcement. It allows officers to act when probable cause exists, even when certainty does not. It validates reliance on training and experience, so long as decisions are fact-based. It protects officers who act reasonably and restrains those who do not. Brinegar v. United States does not expand authority recklessly. It defines authority carefully, and that careful definition is what allows lawful arrest, lawful search, and lawful seizure to stand when examined later. Brinegar v. United States protects officers who act reasonably in uncertain situations. It allows probable cause to be based on practical judgment, not mathematical proof. It recognizes the realities of police work while enforcing constitutional limits. For law enforcement, Brinegar v. United States is the case that says, "You may act on probability, you must act on facts. And you must always be able to explain why. That balance is not accidental. It is the foundation of lawful arrest, search, and seizure." Carroll v. United States, 1925. Carroll v. United States is the case that explains why vehicles are treated differently under the Fourth Amendment. In Carroll v. United States, the court establishes that a warrantless search of a vehicle may be lawful when probable cause exists to believe the vehicle contains contraband or evidence of a crime. The reasoning is not convenience, it is mobility. Vehicles can be moved. Evidence can be lost before a warrant can reasonably be obtained. Under Carroll v. United States, law enforcement is permitted to search a vehicle without a warrant when probable cause is present, and the circumstances make obtaining a warrant impractical. The authority comes from the vehicle's inherent mobility, not from diminished constitutional protections. At the same time, Carroll v. United States imposes a clear limitation. The search must be supported by probable cause before the search begins. The vehicle exception does not allow fishing expeditions. It allows decisive action when facts justify it. This authority is specific. It is not general permission. What Carroll v. United States was. Carroll v. United States involved federal agents who stopped a vehicle they believed was transporting illegal liquor during Prohibition. Based on prior interactions and observations, the agents searched the vehicle without a warrant and discovered contraband. The question before the court in Carroll v. United States was whether the warrantless search violated the Fourth Amendment. The court held that it did not. In doing so, Carroll v. United States created what is now known as the automobile exception to the warrant requirement. What Carroll v. United States requires of law enforcement. Carroll v. United States requires officers to establish probable cause before searching a vehicle. An officer must be able to articulate why the vehicle likely contains contraband or evidence. Mobility alone is insufficient. Suspicion alone is insufficient. Probable cause must exist at the time of the search. Under Carroll v. United States, the scope of the search is limited to areas of the vehicle where the object of the search could reasonably be found. The authority expands with the object sought, not beyond it. The exception allows speed. It does not excuse carelessness. Summary. What Carroll v. United States did for law enforcement. Carroll v. United States allows officers to search vehicles without a warrant when probable cause exists and delay would risk the loss of evidence. It recognizes the practical realities of policing on the roadway. It preserves constitutional boundaries through the requirement of probable cause. It authorizes action without abandoning restraint. Carroll v. United States does not weaken the Fourth Amendment. It teaches how to enforce it, while the evidence is still there. Beck v. Ohio, 1964. Beck v. Ohio is the case that tells officers something critical. Probable cause must exist before the arrest, not be invented after it. In Beck v. Ohio, the court makes clear that an arrest is only lawful if, at the moment it is made, the officer possesses facts and circumstances sufficient to establish probable cause. Explanations developed later, discoveries made afterward, or justifications assembled in hindsight are irrelevant. Under Beck v. Ohio, law enforcement authority rises or falls on what the officer knew at the time of the arrest. The Constitution does not allow an arrest to be validated retroactively. If probable cause was not present when custody began, the arrest is unlawful, even if evidence is later found. This case imposes discipline, not delay. Discipline. What Beck v. Ohio was. Beck v. Ohio involved an arrest made by officers who believed the defendant was involved in criminal activity but could not clearly articulate the facts that supported that belief at the time of arrest. After the arrest, evidence was discovered that appeared to justify their actions. The issue before the court in Beck v. Ohio was whether an arrest could be upheld based on facts learned after the arrest occurred. The court answered no. In Beck v. Ohio, the Supreme Court ruled that probable cause must be evaluated strictly on the information known to the officer at the moment the arrest was made. What Beck v. Ohio requires of law enforcement. Beck v. Ohio requires officers to pause internally before acting and ask a single question. Do I have probable cause right now? An officer must be able to articulate specific facts that justify the arrest at the moment custody begins. Training and experience may explain the interpretation of those facts, but they cannot replace them. Under Beck v. Ohio, arrests based on vague suspicion, reputation, or intuition are unlawful. Evidence found after the arrest cannot rescue a decision that lacked probable cause at its inception. The arrest must stand on its own footing, or it does not stand at all. Summary. What Beck v. Ohio did for law enforcement. Beck v. Ohio draws a firm constitutional line. It teaches officers that probable cause must precede arrest, not follow it. It prevents arrests from being justified by hindsight. It protects lawful arrests by requiring clarity at the moment authority is exercised. Beck v. Ohio does not restrict decisive policing. It refines it. An officer who understands Beck v. Ohio does not rush to arrest hoping the facts will appear later. He arrests only when the facts are already there. United States v. Socolow, 1989. United States v. Socolow teaches officers how reasonable suspicion is formed and how it is defended. This case draws the line between a hunch and a lawful stop. It confirms that officers may rely on the totality of the circumstances, even when each individual fact might appear innocent on its own. United States v. Socolow does not lower the standard. It explains it. What United States v. Socolow did for law enforcement. United States v. Socolow authorizes officers to conduct a temporary investigative detention when specific, articulable facts, viewed together, create reasonable suspicion that criminal activity is afoot. The court makes clear that reasonable suspicion is less than probable cause, does not require proof of a crime, and does not require certainty. Under United States v. Socolow, officers are allowed to connect behavioral indicators, patterns, and context using training and experience. The Constitution does not demand that each factor be criminal by itself. It demands that the whole picture makes sense. This case validates disciplined observation, not guesswork, not instinct alone, disciplined observation. What United States v. Socolow was. United States v. Socolow involved a traveler who was stopped at an airport after agents observed multiple indicators associated with drug trafficking behavior. No single fact proved criminal activity, but together they formed a pattern. The defense argued that these indicators were consistent with innocent travel and that relying on them amounted to an unlawful stop. The Supreme Court rejected that argument. In United States v. Socolow, the court ruled that officers are not required to ignore common-sense inferences simply because each fact could also describe innocent conduct. The question was not whether each fact was innocent. The question was whether all facts together justified suspicion. What United States v. Socolow requires of law enforcement. United States v. Socolow requires officers to articulate why the facts matter together, not merely list them. An officer must be able to explain what was observed, how those observations relate to criminal behavior, and why training and experience make the combination meaningful. This case does not authorize stopping people based on profiles alone. It authorizes stops based on behavior interpreted through experience. The officer must explain the pattern, not just name it. Summary: what United States v. Socolow did for law enforcement. United States v. Socolow clarified reasonable suspicion. It confirmed that reasonable suspicion is based on the totality of circumstances. Innocent facts may become suspicious when combined, and officers may rely on training and experience to interpret behavior. United States v. Socolow does not permit random stops. It permits reasoned ones. An officer applying United States v. Socolow does not say, "Something felt wrong." He says, "These facts together meant something, and I can explain why." Florida v. Royer, 1983. Florida v. Royer teaches restraint. This case explains that reasonable suspicion authorizes investigation, not control. It draws a hard boundary on how far officers may go during an investigative detention before it becomes an arrest. Florida v. Royer is not anti-law enforcement. It is pro-discipline. What Florida v. Royer did for law enforcement. Florida v. Royer clarified that an investigative detention must remain temporary, limited, and proportional to the suspicion that justified it. Under Florida v. Royer, officers may approach and question a person, request identification, and briefly detain the person to confirm or dispel suspicion. But Florida v. Royer makes clear that officers may not move the person to a confined location, retain personal documents without justification, or exert control equivalent to an arrest without probable cause. Reasonable suspicion allows inquiry. Probable cause allows custody. Florida v. Royer enforces that distinction. What Florida v. Royer was. Florida v. Royer involved a traveler stopped at an airport based on drug courier indicators. Officers took his identification and airline ticket, moved him to a small room, and retrieved his luggage without his consent. The officers believed they were conducting an investigative detention. The court disagreed. In Florida v. Royer, the Supreme Court held that the officers exceeded the scope of a lawful detention. By retaining Royer's documents and moving him to a confined space, the encounter escalated into a de facto arrest without probable cause. The evidence was suppressed. What Florida v. Royer requires of law enforcement. Florida v. Royer requires officers to constantly evaluate scope and duration. The officer must ask, "Am I still investigating? Or have I restrained freedom of movement to the degree associated with arrest?" Florida v. Royer teaches that the manner of detention matters as much as the reason for it. Control transforms suspicion into custody, and custody demands probable cause. Summary: what Florida v. Royer did for law enforcement. Florida v. Royer reinforced the limits of reasonable suspicion. It established that investigative detentions must be brief and minimally intrusive. Officers may not escalate control without probable cause, and unlawful escalation will invalidate the stop and its evidence. Florida v. Royer teaches officers not to rush authority. You may investigate calmly. You may not overtake prematurely. That discipline preserves the case and the Constitution. Terry v. Ohio, 1968. Terry v. Ohio is the foundation of stop-and-frisk law. Terry v. Ohio teaches measured action. This case defines the narrow space where an officer may intervene for safety without making an arrest. It explains when observation becomes investigation, and when protection justifies a limited search. Terry v. Ohio is the foundation of stop-and-frisk law. aka a Terry frisk. It is not permission to search, it is permission to protect. What Terry v. Ohio did for law enforcement. Terry v. Ohio established that an officer may briefly detain a person based on reasonable suspicion that criminal activity is afoot, even without probable cause. It also established that an officer may conduct a limited pat-down for weapons when the officer can articulate reasonable suspicion that the person is armed and dangerous. This is not a search for evidence, it is a search for safety. Terry v. Ohio gave officers lawful authority to stop a person briefly to investigate suspicious behavior and frisk the outer clothing solely to locate weapons. Nothing more. What Terry v. Ohio was. Terry v. Ohio arose when an experienced officer observed individuals repeatedly casing a store window in a manner consistent with a planned robbery. Based on those observations, the officer stopped the men and conducted a pat-down, discovering weapons. The Supreme Court upheld the officer's actions. In Terry v. Ohio, the court ruled that the officer's observations created reasonable suspicion and that officer safety justified a limited frisk for weapons. The stop was lawful. The frisk was lawful because both were restrained. What Terry v. Ohio requires of law enforcement. Terry v. Ohio requires articulation. The officer must be able to explain what specific behaviors created reasonable suspicion and why safety justified a frisk. Terry v. Ohio forbids exploratory searches for evidence, and any frisk not strictly tied to officer safety. The scope is narrow by design. Once the threat is resolved, the intrusion must end. Summary: what Terry v. Ohio did for law enforcement. Terry v. Ohio created the modern investigative detention. It teaches that reasonable suspicion permits a brief stop, officer safety permits a limited pat-down, and restraint preserves legality. Terry v. Ohio did not lower standards. It refined them. An officer does not dominate the encounter. An officer controls risk, briefly, carefully, and lawfully. That is the discipline Terry v. Ohio demands. United States v. Mendenhall, 1980. United States v. Mendenhall teaches restraint before authority. This case defines the line between a consensual encounter and a seizure. It answers a quiet but decisive question. When does police presence become constitutional restraint? United States v. Mendenhall does not focus on force. It focuses on freedom. What United States v. Mendenhall did for law enforcement. United States v. Mendenhall established the legal test for determining when a person is seized under the Fourth Amendment. The court held that a person is seized only if, under the totality of the circumstances, a reasonable person would believe they are not free to leave. This means law enforcement officers may approach individuals in public, ask questions, request identification, and request consent so long as the encounter remains voluntary. No seizure occurs unless authority replaces choice. What United States v. Mendenhall was. United States v. Mendenhall arose when federal agents approached a woman in an airport, identified themselves, asked questions, and requested consent to search. She cooperated and consented. The issue was whether the initial contact constituted a seizure. The Supreme Court held that it did not. In United States v. Mendenhall, the court ruled that the officers did not block her movement, did not display weapons, did not use commanding language, and did not convey that compliance was required. Because she remained free to leave, no seizure occurred. What United States v. Mendenhall requires of law enforcement. United States v. Mendenhall requires officers to understand how authority is perceived. Factors that may turn an encounter into a seizure include the presence of multiple officers, display of weapons, physical touching, commanding or authoritative language, or blocking a person's path. Absent those factors, contact may remain consensual. United States v. Mendenhall teaches that tone, posture, and positioning matter. Authority does not begin when a badge appears. It begins when freedom disappears. Summary. What United States v. Mendenhall did for law enforcement. United States v. Mendenhall defined the modern consensual encounter. It teaches that officers may engage without suspicion, citizens retain the right to decline, and a seizure occurs only when freedom is restrained. United States v. Mendenhall protects lawful policing by rewarding discipline. An officer who understands this case does not rush control. They allow choice until law requires otherwise. That is how legitimacy is preserved. Dyer v. State, Texas Court of Criminal Appeals, 2003. Dyer v. State teaches coordination without dilution of responsibility. This case answers a practical question every officer eventually faces. Must the officer who makes the arrest personally possess all the facts establishing probable cause? Dyer v. State says no, but with discipline. What matters is not who knows, but that the knowledge exists within lawful law enforcement channels. What Dyer v. State did for law enforcement. Dyer v. State formally affirmed the collective knowledge doctrine under Texas law. The court held that probable cause may be based on the combined knowledge of multiple officers involved in an investigation, even if the arresting officer does not personally know every fact that establishes probable cause at the moment of arrest. This means law enforcement may operate as a coordinated body rather than isolated individuals. Officers may rely on information communicated by other officers, act on bulletins, briefings, radio traffic, or directives, and make arrests based on shared investigative knowledge. Probable cause does not have to live in a single mind. It may exist within the team, what Dyer v. State was. Dyer v. State arose from a coordinated investigation in which one officer developed sufficient probable cause, while another officer, acting on that information, made the arrest. The defense argued that the arresting officer lacked probable cause because he did not personally observe or know all of the facts. The Texas Court of Criminal Appeals rejected that argument. In Dyer v. State, the court ruled that probable cause may be established through collective police knowledge. Communication between officers is sufficient, and the arrest remains lawful so long as the originating officer possessed lawful probable cause. The law does not require redundancy. It requires reliability. What Dyer v. State requires of law enforcement. Dyer v. State does not grant blind authority. It requires structure. For collective knowledge to justify an arrest, the originating officer must actually have probable cause. The information must be part of a legitimate investigation, and the arrest must be connected to that shared knowledge. An officer may rely on another officer's judgment, but not on assumption, rumor, or convenience. If no officer had probable cause, the arrest fails. Shared ignorance is still ignorance. Summary. What Dyer v. State did for law enforcement. Dyer v. State allows modern policing to function as it must, collaboratively. It teaches that probable cause may be pooled, communication preserves legality, and coordinated action is constitutionally sound. But it also teaches restraint. Authority shared must still be authority earned. An officer who understands Dyer v. State does not hesitate to act when properly informed, and does not act when the foundation is absent. That balance is not efficiency, it is legitimacy, maintained through discipline. Payton versus New York, 1980. Payton versus New York teaches restraint at the threshold. This case defines one of the firmest lines in Fourth Amendment law, the entrance to a home. It answers a question every officer must carry clearly in mind. When does probable cause end and judicial authority become required? Payton v. New York does not concern whether an officer believes a felony has occurred. It concerns where that belief may be enforced. What Payton v. New York did for law enforcement. Payton v. New York established a constitutional rule that is absolute in its clarity. Absent consent or exigent circumstances, law enforcement may not enter a private residence to make a routine felony arrest without an arrest warrant. Probable cause alone is not enough. This decision requires officers to understand that. The home receives the highest level of Fourth Amendment protection. An arrest warrant carries with it limited authority to enter a suspect's residence, and warrantless home entries are presumptively unreasonable. Authority pauses at the doorway unless lawfully authorized to cross it, what Payton v. New York was. Payton v. New York arose from cases where officers entered private homes without warrants to make felony arrests, relying solely on probable cause. The question before the Supreme Court was whether the Fourth Amendment permitted that practice. The court answered no. In Payton v. New York, the Supreme Court held that physical entry into the home is the chief evil against which the Fourth Amendment is directed. Warrantless entries for routine felony arrests violate constitutional protections, and judicial approval must come before the intrusion, not after. The Constitution does not reward urgency when patience is required. What Payton v. New York requires of law enforcement. Payton v. New York requires officers to distinguish between public spaces and private dwellings, authority to arrest and authority to enter, and necessity versus convenience. Officers may enter a home without a warrant only when valid consent is given, or exigent circumstances exist, such as immediate danger, destruction of evidence, or hot pursuit. Absent those conditions, the proper response is not force, it is procedure. An officer who understands Payton v. New York knows that waiting for a warrant is not hesitation. It is constitutional compliance. Summary: what Payton v. New York did for law enforcement. Payton v. New York drew a clear constitutional boundary at the door of the home. It teaches that probable cause authorizes belief, warrants authorize entry, and homes are protected spaces requiring judicial approval. Lawful authority is strongest when it is restrained. An officer who honors Payton v. New York does not lose control of the situation. They preserve the case before it ever reaches court. That is not weakness. That is mastery of the Fourth Amendment. Illinois v. Gates, 1983. Illinois v. Gates teaches judgment over rigidity. This case reshaped how courts evaluate probable cause. It rejected formulaic thinking and replaced it with disciplined common sense. The question it answered was not whether information fit neatly into boxes, but whether, taken as a whole, it justified action. Illinois v. Gates reminds officers that the Fourth Amendment is practical, not mechanical. What Illinois v. Gates did for law enforcement. Illinois v. Gates replaced the rigid two-pronged test for evaluating informant tips with a totality of the circumstances approach. Before Illinois v. Gates, courts required strict proof of an informant's credibility and the basis of the informant's knowledge. After Illinois v. Gates, those factors still matter, but they are no longer decisive on their own. Instead, officers and magistrates may consider corroboration by police investigation, patterns of behavior, predictive detail, and the overall reliability of the information when viewed together. Probable cause is no longer a checklist. It is a reasoned conclusion. What Illinois vs. Gates was. Illinois vs. Gates arose from an anonymous letter alleging drug trafficking. The letter lacked direct proof of credibility and did not clearly explain how the writer knew the information. However, officers corroborated key details through surveillance. The issue before the Supreme Court was whether the warrant was invalid because the tip failed to meet the old rigid test. The court held that it was valid. In Illinois vs. Gates, the Supreme Court ruled that probable cause depends on the total picture. Deficiencies in one area may be offset by strength in another, and magistrates must make practical, common-sense decisions. Certainty is not required. Reasonableness is. What Illinois vs. Gates requires of law enforcement. Illinois vs. Gates requires officers to think holistically. Officers must document corroboration, articulate how facts connect, and present a complete narrative to the magistrate. An unverified tip alone is not enough, but a verified pattern, reasonably interpreted, may be. This case rewards disciplined investigation and careful articulation. Summary: what Illinois vs. Gates did for law enforcement. Illinois vs. Gates modernized probable cause analysis. It teaches that probable cause is fluid, not fixed. Credibility grows through corroboration, and lawful decisions come from the whole story, not isolated facts. An officer who understands Illinois vs. Gates does not chase certainty. They assemble reason. That is how constitutional policing adapts, without surrendering its principles. Miranda vs. Arizona, 1966. Miranda vs. Arizona teaches restraint over confession and established the practices of reading a suspect their Miranda rights. This case governs not how officers speak, but when silence must be honored. It answers a question that sits at the center of custodial policing. When does questioning become coercion under the Constitution? Miranda vs. Arizona is not about preventing investigation. It is about preserving legitimacy when liberty is restrained. What Miranda vs. Arizona did for law enforcement. Miranda vs. Arizona established that when a person is subjected to custodial interrogation, law enforcement must advise that person of specific constitutional rights before questioning. Those rights include the right to remain silent, the warning that anything said may be used against them, the right to consult with an attorney, and the right to have an attorney present during questioning. Without these warnings, statements obtained during custodial interrogation are inadmissible in the prosecution's case in chief. The case does not prohibit questioning, it conditions it. What Miranda v. Arizona was. Miranda vs. Arizona arose from custodial police questioning conducted without informing suspects of their Fifth Amendment rights. The Supreme Court examined whether statements obtained under those circumstances were truly voluntary. The court held that they were not. In Miranda vs. Arizona, the court ruled that custodial interrogation carries inherent psychological pressure. Silence is a constitutional right, not an obstacle, and safeguards are required to protect against compelled self-incrimination. The Constitution does not rely on good intentions. It relies on structure. What Miranda v. Arizona requires of law enforcement. Miranda v. Arizona requires officers to recognize three elements clearly: custody, interrogation, and timing. When a person is in custody and subjected to interrogation, warnings must come first. If a suspect invokes the right to remain silent or the right to counsel, questioning must stop. This case demands discipline in speech, patience in process, and respect for invocation. An officer who understands Miranda v. Arizona knows that compliance protects both the suspect and the case. Summary: What Miranda vs. Arizona did for law enforcement. Miranda vs. Arizona defined the rules of custodial questioning. It teaches that silence is not suspicious, warnings are not optional, and confessions obtained without structure will not stand. An officer who honors Miranda vs. Arizona does not lose authority. They preserve it by ensuring that every word obtained is lawful, voluntary, and defensible. That is not a limitation on policing. That is the foundation of admissible truth. Maryland vs. Schatzer, 2010. Maryland vs. Schatzer teaches finality without permanence. This case clarifies how long an invocation of the right to counsel or to remain silent continues to shield a suspect from renewed custodial interrogation, this being 14 days. The Supreme Court held that when a suspect invokes the right to counsel, law enforcement may not reinitiate custodial interrogation unless counsel is present or there has been a break in Miranda custody lasting at least 14 days. After that break, officers may again approach the suspect, provide fresh Miranda warnings, and lawfully seek a waiver. What Maryland vs. Schatzer was. Maryland vs. Schatzer involved a suspect who invoked his right to counsel during custodial interrogation. Questioning stopped, as required. Years later, after the suspect had returned to the general prison population and was no longer in Miranda custody, officers reapproached him, re-advised him of his rights, and obtained statements. The issue before the court was whether the original invocation permanently barred all future police-initiated questioning. The Supreme Court held that it did not. In Maryland vs. Schatzer, the court ruled that the coercive pressures of custody diminish after a meaningful break. A return to normal life or normal incarceration resets the Miranda environment, and a 14-day period is sufficient to restore free choice. Time, when structured, restores balance, what Maryland vs. Schatzer requires of law enforcement. Maryland vs. Schatzer requires officers to understand custody as a condition, not a label. Officers must determine whether the suspect was truly released from Miranda custody, whether at least 14 days passed before reinitiation, and whether fresh Miranda warnings were properly given. Absent those elements, renewed questioning is prohibited. This case rewards patience and planning. It punishes shortcuts. Krieger v. State, Texas Court of Criminal Appeals, 1997. Krieger v. State teaches patience before intrusion. This case governs one of the most common and most misunderstood moments in policing, the knock and talk. It answers a simple but decisive question. When does an officer's presence at a door remain lawful? And when does it become a search or seizure? Krieger v. State reminds officers that the Constitution allows approach, not compulsion. What Krieger v. State was. Krieger v. State arose when officers went to a residence, knocked on the door, and engaged the occupant without entering the home or asserting authority to compel compliance. The issue was whether the officer's conduct constituted an unlawful search. The Texas Court of Criminal Appeals held that it did not. In Krieger v. State, the court ruled that approaching a front door is not a search, knocking is not a seizure, and conversation is lawful so long as the occupant remains free to refuse. The Constitution does not forbid contact. It forbids coercion. What Krieger v. State requires of law enforcement. Krieger v. State requires officers to remain within the boundaries of implied consent. That means no entering curtilage beyond normal access points, no peering into windows, no lingering after refusal, and no conduct suggesting compliance is required. The moment an officer exceeds what an ordinary citizen could do, the protection ends. An officer who understands Krieger versus State knows when to step forward and when to step back. Summary: what Krieger v. State did for law enforcement. Krieger v. State legitimized the knock and talk when done correctly. It teaches that approach is lawful, conversation is voluntary, and refusal must be respected. An officer who honors Krieger versus State does not force entry. They invite dialogue and accept the answer. That restraint preserves both the investigation and the Constitution. Steigold v. United States, 1981. Steigold v. United States teaches restraint beyond the threshold. This case answers a precise and often misunderstood question. What authority does an arrest warrant actually provide? And where does that authority end? Steigold v. United States makes clear that an arrest warrant names a person, not a place. What Steigold v. United States did for law enforcement. Steigold v. United States established that an arrest warrant alone does not authorize entry into a third party's home to search for the person named in the warrant. When officers seek to enter the home of someone other than the suspect, the Constitution requires more. Specifically, officers must have a search warrant for that residence, or valid consent, or exigent circumstances. An arrest warrant protects the suspect's liberty interest. A search warrant protects the homeowner's privacy interest. The two are not interchangeable. What Steigold v. United States was. Steigold v. United States arose when officers, armed with an arrest warrant for a suspect, entered a third party's home without a search warrant while looking for that suspect. The suspect was not found, but contraband belonging to the homeowner was discovered. The government argued that the arrest warrant justified the entry. The Supreme Court rejected that argument. In Steigold v. United States, the court held that the homeowner's Fourth Amendment rights were violated. The arrest warrant did not authorize the search of the home, and evidence discovered during the unlawful entry must be suppressed. The Constitution protects the innocent occupant as much as it restrains the guilty suspect. What Steigold v. United States requires of law enforcement. Steigold v. United States requires officers to identify whose home they are entering and why. Before crossing the threshold of a third party's residence, officers must ensure that lawful authority exists to search that location. Belief that the suspect may be inside is not enough without judicial authorization or an exception. This case demands precision: whose warrant, whose home, and under what authority. Assumption is not authority. Summary: what Steigold v. United States did for law enforcement. Steigold v. United States clarified the limits of arrest warrants. It teaches that arrest warrants authorize custody, not searches of third-party homes. Search warrants protect the privacy of those not named, and constitutional authority must match the intrusion. An officer who understands Steigold v. United States does not confuse urgency with permission. They secure the proper warrant, they respect the threshold, and they preserve the case by honoring the home. That is lawful enforcement, exercised with discipline. Brigham City, Utah v. Stewart, 2006. Brigham City v. Stewart teaches decisive action when safety is at stake. This case explains the emergency aid doctrine, the narrow but vital authority that allows officers to enter a home without a warrant when immediate harm is occurring or imminent. The Constitution does not require officers to stand idle while violence unfolds. What Brigham City v. Stewart did for law enforcement. Brigham City v. Stewart established that officers may enter a home without a warrant when they have an objectively reasonable belief that someone inside is seriously injured or imminently threatened with such injury. The justification is not investigation. It is protection. Under this case, entry is lawful when the purpose is to stop ongoing violence, prevent serious injury, or render emergency aid. The officer's subjective intent is irrelevant. What matters is whether the circumstances would cause a reasonable officer to act. What Brigham City versus Stewart was. Brigham City versus Stewart arose when officers responded to a loud party and observed, through a window, a physical altercation inside a home. One individual was struck and bleeding. Officers entered without a warrant and arrested those involved. The occupants argued the entry was unlawful. The Supreme Court disagreed. In Brigham City versus Stewart, the court held that officers need not wait for violence to escalate further. The visible fight justified immediate entry, and the Fourth Amendment permits action to prevent injury. Safety does not pause for paperwork. What Brigham City versus Stewart requires of law enforcement. Brigham City versus Stewart requires officers to act based on objective reasonableness, not curiosity or convenience. The entry must be limited to addressing the emergency no broader than necessary and tied directly to the threat observed. Once the emergency ends, so does the justification. This case authorizes action, but only for as long as danger exists. Summary: what Brigham City versus Stewart did for law enforcement. Brigham City versus Stewart confirmed that the Constitution does not require passivity in the face of violence. It teaches that emergency aid justifies warrantless entry, objective danger overrides delay, and protection of life is a constitutional priority. An officer who understands Brigham City versus Stewart does not hesitate when harm is imminent. They intervene calmly, lawfully, and only as far as necessary. That is authority exercised in service of safety. Kentucky v. King, 2011. Kentucky v. King teaches the boundary between lawful presence and manufactured urgency. This case addresses a recurring tension in policing. When officers create circumstances that lead to an exigency, does the Constitution still permit warrantless action? Kentucky v. King answers carefully, neither indulgently nor restrictively. What Kentucky v. King did for law enforcement. Kentucky v. King held that law enforcement may rely on exigent circumstances to enter a residence without a warrant, so long as the exigency was not created by a violation of the Fourth Amendment. In other words, officers do not lose lawful authority simply because their presence prompts a suspect to act, provided the officers were lawfully where they were allowed to be. Lawful conduct may lead to urgent consequences. Unlawful conduct may not. This case rejects the idea that officers must predict and avoid every possible reaction by a suspect. What Kentucky v. King was. Kentucky v. King arose when officers followed a suspect into an apartment complex, lost sight of him, and smelled marijuana coming from one of the doors. Officers knocked, announced themselves, and then heard sounds consistent with destruction of evidence. They entered without a warrant. The defense argued that the officers created the exigency by knocking and announcing. The Supreme Court disagreed. In Kentucky v. King, the court ruled that knocking and announcing is lawful. Police conduct officers are not required to ignore suspicious circumstances, and exigent circumstances remain valid unless officers violate the Fourth Amendment to create them. The Constitution restrains misconduct, not presence. What Kentucky v. King requires of law enforcement. Kentucky v. King requires officers to evaluate how an exigency arose. Officers must ensure that their initial conduct was lawful, they did not threaten unlawful entry, and they did not coerce behavior that created the emergency. If the exigency follows lawful action, the authority stands. If the exigency follows constitutional violation, it does not. This case demands discipline at the beginning, so authority exists at the end. Summary: what Kentucky v. King did for law enforcement. Kentucky v. King clarified the limits of exigent circumstances. It teaches that lawful police conduct does not invalidate exigency, suspects' reactions do not erase authority, and constitutional compliance preserves options. An officer who understands Kentucky v. King does not manufacture urgency. They act lawfully and allow the law to respond when urgency arises. That is restraint aligned with decisiveness. That is constitutional authority preserved. United States v. Santana, 1976. United States v. Santana teaches continuity of authority. This case explains what happens when a lawful arrest begins in public, and the suspect attempts to retreat into private space to avoid it. It answers a narrow but critical question. May an officer continue a lawful arrest into a residence when the arrest is already in motion? United States v. Santana says yes, when the pursuit is immediate and uninterrupted. What United States v. Santana did for law enforcement. United States v. Santana established that a suspect may not defeat a lawful public arrest by stepping into a residence at the last moment. When officers have probable cause and initiate an arrest in a public place, they may pursue the suspect into a private residence under the doctrine of hot pursuit. The authority does not reset at the doorway. It continues briefly and narrowly. This is not an exception created for convenience. It exists to prevent escape. What United States v. Santana was. United States v. Santana arose when officers approached Santana while she was standing in the open doorway of her home, a space considered public for Fourth Amendment purposes. As officers identified themselves and moved to arrest her, she retreated into the house. Officers followed her inside without a warrant and completed the arrest. The defense argued the entry violated the Fourth Amendment. The Supreme Court disagreed. In United States v. Santana, the court held that the arrest began in a public place. The retreat into the home did not negate lawful authority, and the officer's entry was justified by hot pursuit. Flight does not erase jurisdiction. What United States v. Santana requires of law enforcement. United States v. Santana requires immediacy. The pursuit must be continuous, directly connected to the attempted arrest, and limited to completing that arrest. This case does not authorize planned entries or delayed pursuits. It authorizes completion of an arrest already lawfully underway. An officer who understands United States v. Santana acts decisively, but only in the moment that demands it. Summary: what United States v. Santana did for law enforcement. United States v. Santana preserved lawful arrests against tactical retreat. It teaches that public arrests cannot be undone by crossing a threshold. Hot pursuit allows brief warrantless entry, and continuity of action preserves authority. An officer who applies United States v. Santana does not pause at the doorway when flight begins. They finish the arrest lawfully, immediately, and without excess. That is authority carried through to its conclusion.